All right, we are live and recording for our Theranos discussion and exam prep. So we've got kind of two things going on today. First of all, welcome to exam week. So this is super exciting for you all. I know you've been waiting for this all semester, but exam one opened, let's see, I guess it opened early this morning. And I did just check. Nobody's taken it yet, so not surprised. We haven't even done the exam prep yet. So, but that is open, and then you have until tomorrow night, so Saturday night at 11:59 p.m. So get that in. Let's do some top hat questions today just to help get you ready for that. But overall, that's exciting. Okay. And maybe we start with that. So I'm gonna open up Top Hat real quick and let you take a couple of questions here. And this will help you kind of judge where you are right now. Again, after you take these Top Hat questions, if you're really concerned and kind of scared about anything, then I'm gonna have you get in touch with the tutor. Olivia is like ready to help you out. And Brandon, who's here, can also help you out. So let's see. I'm just kind of pulling this up real quick. Let's start with this. Okay, this will be a good one. Okay, so let me share the screen here with you. Okay, so on this screen, let me present this for you. So I won't take attendance today, but again, if you have your phones at the ready, you probably already joined the class. Let's just jump into the question itself. So here you've got Jenny arguing a case as to why the police did not have authority to search her client's car. So Jenny's going to be the attorney in this question. The judge asks for relevant statutory precedent to support the argument that Jenny is making. So which of the following would be appropriate to cite? So basically this question is, which one of the followings is a statute? Right, so go ahead and take your best guess here, and then I'll help you out. So take 30 seconds. I'll give you 30 seconds.
Do you know what dorsal means? Back.
All right, let's go ahead, and 5 of you are still kind of wondering what to do, but 3 of you now. Let's see. I gotta move this 1 second. All right, so if I close it up, oh, just as one more person got it in. Here, when we're talking about statutes, kind of what to look for is like Idaho code, like these are the codes, right? These are the laws that regulate and are passed by legislatures that say what the law is. So this is the law itself. Always look for a code. So again, Idaho versus Murdoch, if you pick that, that's a case. That's the name of a case. 2 parties against each other. In this case, the state of Idaho versus Murdoch. There's this Idaho code section. You now know that's the right one. This C, that's just an article. Now D is always going to be a little tricky, and I want you to watch for this on the exam, because regulations aren't statutes. Now they may be, but like I'm trying to think of an important regulation. Oh, a lot of you accounting students will know this, but like the IRS regulations, right? Like you can get that big book. It has the code plus all of the regulations. The regulations are passed by governmental bodies that say this is how the law, the statute should be interpreted in a number of different situations. But regulations aren't statutes. They may be used by judges to interpret the statutes, but again, not the law. So again, just I'm glad we did that one. Let me see if I've got another one here for you. Oh yeah. All right, take a look at this one. This will go back to constitutional law stuff, but I'll give you 60 seconds for this one. All right, 5 more seconds. Okay, so again, 3 of you didn't get your answers in on time. That's okay, right? Like this isn't the exam itself, but if I pull up the responses, all right, pretty even split here. I actually kind of like to see when this happens. And that means that I wrote a good question. So anyway, all right. So the Idaho legislature passes a statute that says everybody must turn in their guns. All right. So what is this? Like some of you are saying, well, this law violates the Constitution. Well, that's not in here. So you've got to kind of look for other options here, and really, it's going to come down. Does it violate the Commerce Clause? Maybe, but they might be able to argue, it deals with commerce and interstate. Anyway, it might get past Commerce Clause, but it's going to run up against something else. Oh, my favorite is when people pick D because they go to the Church of Guns or something. Anyway, I can't see who picked that, but that's always a funny one to pick. All right, so D is not the right answer because there's no Church of Guns, despite what some people think. All right, but C is kind of a close one, but again, because guns typically are created and then pass through interstate commerce, I don't know, maybe Commerce Clause would work, but it's good.
Wouldn't that be more of a federal law? Like for it to be commerce, wouldn't it need to be more federal? Because isn't the federal government the one who usually regulates that stuff?
Yeah. So great question. But because state legislatures are still bound by the U.S. Constitution as well, a lot of this would still apply. But for for other reasons. But for C, for the Commerce Clause, I think you're exactly right. Like we get out of the Commerce Clause realm simply because it doesn't apply, because that only applies to Congress, the federal legislature. So Christian, that great comment. So here we kind of have to focus on either A or B, right? Substantive due process and procedural due process. Now in the lecture, go back and check this out if you've forgotten this, because what I need you to remember here is that procedural due process, well, that's easy to remember. That's the procedural stuff. That's like when you are arrested, are you read your rights? Are you given the opportunity to be heard, to have your case heard before an impartial judge? That's procedural due process. Substantive due process, that's the one that when you hear the law, it shocks your conscience, right? This is the one, I think the best way to describe this is like, when you hear this law has passed, do you go like, do you make this face like, what? Like, anyway, just imagine yourself going like, that can't be right. Like if it shocks the conscience because it violates some other fundamental right, for example, pick substantive due process. That's the one that's going to shock your conscience. That's the one that makes you say, no way, that can't be a real law. this is America or something like that, right? Like, and anyway, for all of those reasons, A is going to be the correct answer here. Now, so some of you are like a little concerned because you're like, I just missed 2 questions on this on Top Hat. Like maybe I should drop this class. Chill out, okay? Like don't worry yet. On the real exam, remember you can Google stuff like and take advantage of that. Some people finish the first exam in like 30 minutes because they just plowed through it and went with their gut or whatever. Don't forget that I let you go like Google this stuff. Go Google like what is substantive due process. Enter and see. Anyway, you have plenty of time on this exam. 2 hours is a lot of time for a 25 question multiple choice exam. So I do want you to remember that and to check yourself. Go back to the text. Go back to lectures if you need to. Like I said, it's open book, it's open internet. It's just not open other people, and it's not like open Googling questions and like trying to like talk to people that have taken this class before or whatever. You can't do that. But definitely just pull up the page of like what Cornell Cornell Law has a great website that kind of defines all of this stuff, legal dictionaries, all of that is totally fine. So don't stress out. All right, so that's, let me see, let's do a little bit from this week, right? So let's pick a crimes. Let's go into crimes real quick. Oh, sorry, there's some chat questions. Let me pull this up. Oh, Brandon's got it. Cool. Brandon, you're the man. All right, so here we go. Let's do a couple with crimes, and this again will help you get ready for the exam. All right, got a minute here. Go at it. All right, 10 more seconds. We have a lot of people not close. I'm going to add 15 seconds here for you. There you go. Okay. So here we've got Colton and Quentin. They love pizza. But one day Colton eats all the pizza in the fridge. And anyway, Colton thought he was eating his own pizza, but he actually ate Quentin's pizza. Kind of typical crime of larceny that occurs fairly regularly among roommates here. So is this a crime? All right, so if we go through these answers, let me move something out of the way. All right, so yes, he committed the larceny of crime by unlawfully taking somebody else's personal property. You may think that's the right answer. Well, it seems on the face that it is, but remember, you've got to do the act and have the mental state. And so here we put no. He did the actus reus, so he did the act part of the crime, but he didn't have the mens rea. Like, we're just going to stop right there because B is going to be the right answer. Like, if it was a mistake, and a mistake is a defense to crimes, we're just going to pause it, call the dogs off. I don't know where I come up with my stupid phrases, and say, we're done. Like, he didn't mean to, he thought it was his own. So again, most of you got this one right, so that's great. Let's do it. I'm not going to tell you what kind of. Oh, any questions about that last one, by the way?
Yeah, I do.
Yeah.
So like in the question, it didn't say like, it didn't talk about his intention though. how do you know how do you know he has the intention or not?
Yeah,
From this,
great question. I think the key here is this here, what I'm highlighting right now.
yeah.
Colton realizes that he actually ate Quentin's pizza. I think it's just implied there that like he didn't know beforehand that he was eating Quentin's pizza. So you just have to kind of use what I give you and kind of figure it out. Now, if you got that one wrong, you can remember I allow you to do appeals on these exams, and so you could say Brother Hales, he actually did know, like he knew it was his roommate's pizza and he did eat it, and therefore he has the mental state and and did the action, the actus reus, and therefore it is the crime of larceny. And so if you picked A, I think you'd be totally fine. And remember, with appeals, if you write a good appeal and give me additional detail that shows me why your answer is right, I'm going to give you the points for that. Okay, so but like students that catch stuff like this, like Colton realizes that he actually ate Quentin's pizza and can put that together, like, oh, he didn't have the mental state. I'll allow, like you just get it right automatically and you don't even have to write an appeal. Does that make sense?
How about C though? Like if between A and C, which one do you think is more correct?
Yeah, so C says, yes, he committed the crime of conversion by taking unauthorized, justifiable control of another person's property. And that, I think that's on par with A, but it's missing the fact, it's missing the mens rea requirement too. Does that make sense? It's just, it could be right. You would just have to, in your appeal, give me additional facts that showed that he did actually mean to take somebody else's pizza.
I mean like if you have to pick A and C, which option is more correct?
Oh,
Yeah.
I'd say they're on par with each other. Yeah, those are pretty much equal between each other. To be honest, like the difference between larceny and conversion, in this case, that there's not any real difference there. So I think either of those would be equal.
Okay.
Yeah.
Thanks.
All right, and then okay, so
I've got a question real quick. Sorry.
yeah.
So even though it wouldn't be a crime because he doesn't have the act and intent, could he still be sued in a civil case?
Yeah. So yeah, that's an awesome question. Definitely, because remember, the mental state and the action requirement, those only exist in crimes. So when it comes to civil actions like the tort of conversion, as opposed to the crime of conversion, you don't have to prove mental state. You just have to prove that somebody else took your stuff, and there, because there's no risk of throwing somebody in jail, like losing their liberty, right? We don't really care about the mental state. We just care about the result. So yeah, that's an amazing question. These two requirements for the mental state and the act, those only exist in the realm of criminal law, not so much in torts. In torts, we just care that somebody took your pizza, you sue them, and you get the money back to go buy another pizza. Not that I recommend suing your roommates, but you could if you wanted to. All right. Yeah. Awesome question. All right. Let's go ahead, and this next one, somebody's gonna die. All right. So go ahead and take 60 seconds on this one with Dilbert and his boss. 20 seconds. Okay, let's see what we got here. Move this out of the way. All right, so let's check the responses real quick. All right, so one person, like A, we're gonna throw out not guilty because he lacked the mens rea to injure his coworker. That can't be right. Like somebody died. Anyway, like we can't let you get off because I meant to murder person B, not person A. Like that's just a terrible defense. Like somebody died, you're gonna have to go to jail. All right, so let's scratch A. B is guilty of a crime because he had the mens rea to injure his boss. And that is important, right? Because now we're talking about transferred intent from the boss to the coworker that ended up taking the poison. So, yep, that's going to be the right one. Nobody picked D. C is guilty of a crime because no mens rea is required for criminal assault and battery. It actually is. The only crimes where the mens rea requirement isn't there are like these very few exceptions, like killing a bald eagle, right? Like that, we're just like, you didn't go there. And anyway, forgive my grandpa. All right, so again, B is gonna be the right answer. Great job. Any questions about this one? All right, let's do, I'm just having so much fun here. Let's do one more here with intentional torts. This one's pretty easy, so take just 30 seconds if you can wrap this up. Talking about intent. All right. 5 more seconds for the 7 of you that haven't answered. All right, time's up. Let's check out the responses. Okay, so again, in this one, Bob walks up to Sid and punches him in the arm, breaking his arm. So is he liable for the intentional tort, in this case, battery? Well, yeah, so never, like, remember this. I kind of focused on the lecture. Like, we don't care if Bob only did it because Bob doesn't like Sid, or if Bob has a beef with Sid, if that's even a phrase anymore. Like, we don't care about that. We just care about the harmful touching. Did he have the intent for the harmful touching? And anyway, that's why, let's see, let me pull this one up. Did he intend to punch Sid? Did he intend to have that harmful or offensive touching? If he did, then we're going to have that, like, that's classified as the intentional tort of assault and, well, in this case, battery. And again, what this means is that if it was an accident, if Sid slipped and fell and accidentally hit Bob and broke his arm, Sid would be, or Bob would be intentionally, like, incredibly strong. But you see my point. If this was an accident, then it isn't that. Like then he has the defense to that intentional tort. So again, C, it doesn't matter if he intended to break his arm, just intended to hit him. And only if Bob intended to break it, again, kind of same thing. All right, good. Any questions on this one?
In the question, that he walks up to the guy and punches him. So if he walks up to the guy, it doesn't mean that he's doing it intentionally. Like, I walk up to you and punch you.
Yes. Well, it could be like, you know, so you could be walking up to me to ask a question about business law or something. But I get your point, and it's a great point, and it's one that you want to use to get yourself to the right answer of B.
Okay.
Yeah.
So I have questions.
Uh-huh.
So I read a book about like if you are joking around. I mean, like if Bob and Sid are actually joking because like Bob punched Sid before like a couple times, but Sid didn't think that's a joke.
Yeah.
I mean, like he has the intention to punch him because that he think that's a joke, but accidentally break his arm. This is what I'm thinking. I don't think this intentional towards.
Yeah, and that's why, I mean, that's a good question, because this kind of gets back to the lecture when we were talking about torts of like what if you go up and slap somebody's rear end? Well, you may have like just fun, happy intentions because you do that all the time or whatever. And so that matters, because remember, it has to be harmful or offensive. Um, and in that case, we were talking about the offensive element. Now, it could be you went in with the intent to make a joke of like punching Sid, like maybe they do this all the time. But once it becomes harmful, like once it leaves a mark, or in this case, breaks an arm, now it doesn't matter if it was offensive. Now it matters just that it was harmful. Does that help?
Oh yeah, this helps a lot.
Cool. Cool. Yeah, good question. All right. We could do this all day, but I think you guys have got it. And that was the last one I wanted to do anyway. So
Marcus, quick question.
Yeah.
So I was reading a case for one of my classes about someone who killed I think it was his brother by sleepwalking.
Oh.
Can they be charged of intentional tort for this?
No, because what you do when you're asleep, you lack the intent, right? And with all of these intentional torts and even crimes, where you have in crimes we talk about the mens rea, so that desire to do something wrong or whatever. That's going to be lacking if you're doing it in your sleep, because then it's not a conscious decision. Anyway, and now
So
some of you are like, that doesn't make any sense because everybody could just claim they were sleepwalking. And yeah, it turns into a very difficult case to win to show that you were sleepwalking, because the only witness is the dead person, right? And so if you're relying on the defense of I was sleepwalking to win your case, good luck.
So is that what people who have like mental like illness issues use when like in like let's just say like a school shooting case, like if they're mentally like unstable, then they didn't have the intent because they weren't in the right frame of mind to be thinking logically? Or
yeah, exactly. It's the same defense. Like basically you're saying I didn't understand the consequences of my actions because of some mental deficiency. This is the insanity defense, and yeah, it's very difficult. You have to get in lots of experts. It's very expensive to prove because you're paying a psychologist to fly out from New York or London or whatever, and you're paying that psychologist $2,000 an hour to prove that you really couldn't understand the consequences of your actions. I mean, it's again very difficult, but it is one that lots of people rely on to show that they didn't commit the crime or a tort because they lacked that either intent or the mental state. And we'll talk more about this next week. So next week we get into contracts. I think next week is when this class really like kicks off. Everything that you learn about in contracts and thereafter is extremely important. What we're doing right now is kind of laying the foundation with some constitutional and civil procedure stuff. But yeah, next week we get to contracts and we'll talk about all of that as well, because mental state comes into play to determine whether or not you entered into a contract or not. So yeah, something.
Ask a question?
Yeah.
In these situations, why don't they just take them to court under the common law where only the act matters and not the mental state?
Okay, so when we were talking about that, like the common law, what we really said is a civil trial, which is different than common law in in a very important way. And this kind of goes back to that dichotomies lesson. I think it's important that you understand the difference between criminal law and civil law. Here's what I mean by that. With the criminal, if you are being prosecuted criminally, it means that if you lose, you're probably going to go to jail for some amount of time. And that's why we require the mental state. Whereas with civil trials, it doesn't really, well, what's going to happen if you lose a civil trial? Well, you're going to lose money. And that's sad, like, especially for students. You're like, I don't want to lose any more money than I already have. I get that. But it's not that, like, you can recover from losing money. Whereas going to jail, that can be a horrible experience. And so that's why with the civil trials, we often don't require a mental state element for certain crimes, like these theft crimes, larceny, conversion, etc. We just matter that somebody else took it. We don't care about why. Okay, now what you said is, like, sometimes why don't they just take somebody to court based on well, you said common law. I think, did you mean like civil? Okay. And they do. Like, this is the simple answer. Oftentimes they do. If somebody ever steals from you, oh, this is such an important point. Like, please remember this. If somebody ever steals from you, and this just happened. So one of my friends in our ward here, she owns Olive Avenue. It's this store downtown, Rexburg. And she found out a while back that one of her employees was stealing from her. Well, she could have sued her employee right away, but she decided to wait. And the reason she waited is that she could turn the case over to the city prosecutor, who could sue, well, not sue, well, technically yes, but bring a lawsuit against this former employee under criminal law. And let's say that the prosecutor wins that case. Well, remember, and this is important, like, remember that with criminal trials, we have a very high burden of proof. We have to prove that they did it beyond a reasonable doubt. Like, we have to be 95% sure that they did it. And if you do that, if you win, meaning if this prosecutor, if the state, because the prosecutor represents the state, wins that case against the former employee, then we've established that the former employee did it. And the prosecutor did all the groundwork, all the investigation for you, has a file showing that, yes, this former employee did it. Then right after that, then my friend could bring the lawsuit against the former employee civilly, right? And remember, with that, you just have to prove, like, it's more likely than not that the person did it. And that's so much easier to do once the prosecutor's done it, because now you have all the evidence that the prosecutor gathered for you, instead of having to hire an attorney to do all of the investigation, do all the depositions, do all the discovery, and pay that attorney $300 an hour. Well, you don't have to do any of that because the prosecutor did it for you, and winning the civil case just became so much more easy. So that's kind of a side note, but the short answer is do both. Yeah, let the criminal trial go forward first, and then do the civil trial later. This is exactly what happened with O.J. Simpson too. As soon as the criminal trial was over, the family brought the civil trial next. And even though the criminal trial failed, the civil trial prevailed. That, like, they won that because of the work that the prosecutors had done. Awesome question. Okay, good. Then for the next little bit, I just want to ask and, well, chat with you about really what I consider to be the true financial and corporate crime of this decade. So we had Enron back in the 2000s. I think the 2000s and 2010s, whatever we call that, into even current. it has to be Theranos. And that is how you pronounce it, by the way. Like for a long time, I was like, Theranos? Like I had no idea how to pronounce it. It's Theranos, as you probably saw if you watched some of those videos. And Elizabeth Holmes and Theranos, I can't even tell you like what a big deal this was about 10 years ago. And this all kind of got on the radar to about 2010, 2011. Everybody was talking about the CEO in a black turtleneck from Silicon Valley that was going to just take the world by storm. Her company, because of speculation and Theranos's claims that what they were doing was going to be revolutionary and change the world, this became the hot stock to own. Everybody wanted to own Theranos stock. And as a result of that, and the price of the stock price going through the roof, Elizabeth Holmes became the most wealthy woman in the world very quickly. I mean, she was still young, and yet again, here she was, the most wealthy woman in the world, and admired, and people wanted her to speak at their conventions, and like again, big deal. And I remember even seeing this and thinking, wow, like this is proof that Silicon Valley is really changing the world. And I didn't know much about it. I just watched reports. Luckily, I didn't buy any stock or anything. I just thought, like, this is great. And then, of course, it all comes crashing down. So the purpose of today is to talk about that and really to have a discussion about some ethics as well. But before I get going, let's see, Weston, do you mind just giving us a little background about Theranos, what it is that they do, and just kind of laying a foundation for us real quick?
Sure. Correct me if I say anything incorrect, but I'll tell you what I got from the articles that I read. Basically, this is a company that was claiming that they had a portable device of which they could use to accurately test people's blood, and it would be able to find diseases that they might have, a lot of really important information, but it was extremely accurate, not only accurate, but also very portable, which is something that would be, I mean, completely changing to the industry. It could be on helicopters, it could be in ambulances. It would just really change a lot. And so that's kind of like what their main thing was. And like you said, that's the technology that they were really advertising that got a lot of investors really excited because they all saw that and they're like, that's got to be something I need to be a part of, which I believe is actually what the younger Tyler Schultz also said when he heard about it. He's like, oh, I gotta be a part of this because this is revolutionary. But basically this company that was started by Elizabeth Holmes, which is the woman that you were talking about. She got a bunch of people. I mean, obviously everyone wanted to be a part of this. Tyler Schultz, 26 years old, he joined in as well. And I believe his grandfather was one of the higher, either on the board or something for the company, and he was up there.
That's right. He was on the board, which, yeah, and again, former Secretary of State, like,
right.
The elder Schultz is a big deal, and it
Yeah.
was difficult to get on the board of directors for this company. Like, you basically had to be a Clinton or a Schultz or just a very high power person in order to even like be able to have the opportunity to be on the board of this company. It was so sought after. So yeah, great, Weston. And Christine, are you still on here? I'm trying to see.
Yes, I'm right here.
Oh, cool. Christine, what do you kind of tell us about Tyler Schultz a little bit? Kind of pick up where Weston was talking about. Tyler Schultz decides to go work for this company and kind of figures out something doesn't smell right. Like, talk about that a little bit.
Right. So the blood testers that they had, they were claiming that they had, I think, about like 95% accuracy. But actually, higher ups were telling people that if they had like outliers in their testing, to just kind of throw that data out. And so realistically, they had, I think it was said 60 to 85% accuracy. Tyler Schultz was aware of this, and he decided to come forward. So he like sent some emails to some people that were high up there, and then they tried to like sue him because I'm not quite sure, like they had him contractually somehow agree to like not be able to spill these trade secrets. I'm not exactly sure how, but they tried to sue him for spilling that, and then he was like denying talking to the reporters. And he's basically saying like fraud isn't a trade secret, so you can't sue me for like exposing you about fraud. And
Right. And Christine just hit on like one of the best one-liners that is absolutely true and so important. And I think to fully understand that the idea is here, like fraud isn't a trade secret. We kind of have to understand what was really going on. Did they ever have the ability to do what they said that they could? Remember, like the tagline was one drop of blood. We can run hundreds of tests based on one drop of blood. And goodness, if that was true, I mean, that may sound kind of silly or like who cares? But this is a big deal. Like if you want hundreds of tests done, man, they're going to take vials and vials and vials of blood from you. It's going to take a long time. It's very expensive. They run it through all of these different machines. And yet with Theranos, one drop of blood just from a finger prick, they put it into this tiny portable Edison machine, like Weston was talking about, that you would have. If any of you live in Arizona, they probably had an Edison machine in your local Walgreens. This was a huge deal, very simple to get and to move around and to do all of these tests. And it was all a lie, like it wasn't accurate. And to cover up the inaccuracies, if they ever got blood samples to their lab, they would ask for more than one drop of blood, and then they'd run it through all of these other machines that they had at their headquarters or whatever in the Bay Area. And yeah, Christine is exactly right. Tyler finds out what's going on once he starts as an intern, kind of moves his way up, full-time position after graduation, and realizes that they're getting all kinds of false positives, that the machines simply are not accurate, and yet the company is still making representations telling other people that it is accurate and that it's going to be revolutionary. You can see the problem here, right? And when Tyler starts to make noise internally, this is where we get that great email from Sunny. Yeah, some of you are like, oh yeah, that was crazy. Sunny, like how did Sunny respond when Tyler sent this email to Elizabeth? Well, Elizabeth doesn't even respond. Sunny is like her fixer or whatever. And how does he respond? Like a jerk. like you idiot, you wouldn't be here if your grandpa wasn't the former Secretary of State. You're stupid. And that's an important thing to focus on, I think, because sometimes when you're new and you stumble across something, I think oftentimes many of you will find this when you start working. You'll be like, oh my gosh, we're doing something illegal or unethical, and I need to bring this up to somebody. But how confident are you? Well, probably not that confident. You're the new person. You're like, you're thinking your boss, your boss has been working in this industry for 20 years. Like he or she must surely know better, right? And so I think Sunny's response was probably how he responded to at least 30 other people before Tyler, demeaning them, making them feel stupid, telling them they're lucky to be there, shut their mouth and fall in line. And the question that I really want you to think about is, how would you respond to that? Well, I think clearly most people would respond by just shutting up and getting back to work and being thankful for their $200,000 a year job that they've got, um, so that they could afford a 1-bedroom shack in the Bay Area. Um, I think most people would probably just be happy with that. But I need you to think about, like, what would you do? Well, what did Tyler do? Well, but like Christine said, she saw that he didn't give up. He started looking elsewhere. He reached out to the Wall Street Reporter, gave anonymous tips to government entities that oversee the biomedical field, and it escalated. He told his grandpa, and his grandpa didn't believe him, and how disheartening that must be. That all of that, I think, is just incredibly tough, and more than that, like did you guys catch on what happened when he went to his grandpa's house that one time, and his grandpa was like, yeah, come over, no lawyers, we'll just talk man to man. His grandpa had lawyers in the next floor up. Like, holy cow, like, this is a dysfunctional family, like, if I've ever seen one. And what's nuts is that, like, when the grandpa told the lawyers to come down, what did they have in their hand? Like, they already had a pre-printed settlement agreement, like a negotiated agreement, like, written out, and how crazy that all was. Anyway, let's see. Brendan LeMay, you're one of the other experts today. Anything that you want to jump in and talk about while we're here?
I just can't believe the courage of Tyler. With all that going on, all the opposition that he had, he was still able to stand up to that and do the right thing and hold firm to his belief no matter what was going on. And I'm sure he didn't have like all the pieces to the puzzle either, but he just knew that something was not going right, and so he needed to do that.
Yeah, gosh, that is such a great point, Brendan. Like, I have you read this, and I kind of focus on Tyler's story because we could focus more on the criminal elements of it, and we'll get there too. But I love Tyler as an example to all of you. Now, here's kind of what I was hinting at before. And Brendan, you can jump in if you want to say anything about this, because you hinted at it too. Tyler was persistent. He kept bringing it up when his questions weren't answered adequately. Like, he went to somebody else. Like he kept this up.
There's a question though.
Yeah.
So I mean, like, for normal people, they wouldn't be able to afford the fee of the lawsuit, and also it could potentially involve in defamation if he lost. So
Yeah.
if he don't have enough evidence, and he don't have good lawyer, he might potentially lose, even though he's at the right side, and he'll be out of pot. I mean, like, he can be bankrupt easily.
Yeah, and you're going exactly where I was headed, right? Tyler wasn't the first one that figured this out, but he was the first one that kept escalating it until the Wall Street Journal got it. Why? Well, I want you, like, most of you are probably, like, you had, your financial situation was probably like mine. Like, my family was okay, but, like, we didn't have money. Tyler came from one of the wealthiest families in the country. All right, like, very privileged upbringing. Parents had plenty of money, and they still had to take out, like, did you catch this? They had to get another mortgage on their house just to keep paying the legal bills that kept piling up. Why? Because Theranos was a legal bully. They knew, like, Theranos knew when Elizabeth Holmes went on Mad Money and talked about, how this is all a scam, like this is all a lie, like, they are legit. Like, she said this with a straight face, knowing that they couldn't do what they said they were doing. Like legit sociopath at least, sociopath mentality here of just being able to lie so easily. And and they had money. Like Theranos had lots of money. And so they could be a legal bully. They could keep pushing Tyler and keep adding on additional lawsuits for defamation, for interference with contracts, like a lot of the torts that you guys learned about. And stretch out all of the discovery phase and Tyler rack up nearly $500,000 in legal bills. They could do that. And again, awesome points, because Tyler was like maybe one of the few employees there that had the financial resources to fight back at least a little bit. Again, his parents trusted him enough to basically take out a second mortgage on their house to be able to pay these legal bills. Anything else that anybody wants to bring up there? I
just kind of had a question.
Yeah.
Okay, because I kind of heard about that, or I'm not sure to the extent of this fact, but I know you can break contracts if what they were doing is clearly illegal without any like severe repercussion, that they couldn't sue you for that. So I was thinking that the reason why they were still trying to sue for that was just to intimidate them enough. Because I know a slap suit is also a real thing, that big companies will try to silence poor families by threatening lawsuit.
Mm-hmm.
I know they would clearly lose, but they still do it to scare people into thinking that they're going to have to pay these legal fees.
Yep. And that's exactly right. You may be very right, but you still have to prove to a court, to a judge, that you're right. And that is what can quickly, especially in San Francisco, have $500,000 in legal fees in a couple weeks, maybe months. Like that's how scary. This is the way that people can use the legal system to basically blackmail people into silence. Because even though you're right, you still have to prove it in court that you're right. And to do that, you need attorneys and experts and discovery depositions, and that costs a ton of money. And so, yeah, Emma, that great, excellent point.
Brother Hell, I was like researching more about this yesterday, and I saw an interview that he did like just last year. And he says that even though he didn't regret how the process went, like of course it cost him like $400,000 to like go through all the files. And the interesting part is like they never went to court. Like it was all invested in lawyers. But he mentioned the SEC, so the Security and Exchange Commission. He says like because they have a whistleblower protection, so they avoid. They protect whistleblowers, and basically you avoid all the court cases. So he was like, if I shouldn't know that the SEC would have protected me, I would go with them first instead of like going to the journalist or wherever. So he would have like shifted away from all those $400,000 that he spent on lawyers. And it was really interesting. I have no idea that you could like there was a agency that could protect you that way.
Yeah, and that's possible, but it's kind of theoretical. Like you have to convince the SEC that you're right first before they'll pick up the legal tab. And even if Tyler would have asked, they may not have known enough to be like, yes, we're going to protect you. Tyler still may have been on his own, is what I'm trying to say. And that's why, again, Tyler wasn't the first one to figure this out. But a lot of the people, if they had my financial upbringing where I got out of college and maybe I was smart and I went to BYU Idaho, like all of you, with like the lowest tuition of any school out there, right? And I had very little school debt, I would still be like barely scraping by to live in San Francisco. And with even like the minor threat of a lawsuit against me, I don't know that I would have had the courage that Tyler Schultz did. But this is exactly why I like this story so much. Most of you are like me. You'll get out of here. You won't have a ton of debt, but you won't have any money either. And when these things happen, like remember what Lucas said, like the SEC may be able to help you, but even if they can't, I want you to still choose now to be like Tyler and face and risk that financial insecurity to do the right thing. Because I promise that you'll be okay in the end, right? Like these bully companies, and it's not just Theranos. This is like many, like I don't want to say most companies, but a lot of companies will threaten lawsuits to protect their bottom line. And having
Celebrities also.
Say that again?
Celebrities will also do the same thing.
Absolutely. Yeah.
Companies, people themselves will do it.
I've seen even small startups with no money yet, they still use the law as more of like a weapon than a way to assist their company. They use it to scare other people for intellectual property reasons, for whatever. I just want you to like choose now that you'll do the right thing no matter what. So, good.
Questions.
Yeah.
Do you get the money and time? Did you get the money and time you invest in the lawsuit in pursuing a winning of lawsuit back once you win the lawsuit?
Great question. That's a black hole. Like technically let me say it like this. In some cases you can, but it's hardly ever guaranteed. The law says that the winning party gets attorney's fees paid by the losing party in contracts cases. That's kind of the one consistent issue. Now, this wasn't a contracts case, so usually you don't get your attorney's fees paid by the other side. Now, this is where the US is kind of different than other countries. Other countries will just kind of have it built in that if you lose, then you have to pay the other side's attorney's fees. And we haven't done that in the US, except for contracts cases. And then a couple states have some exceptions to that. But here's the problem. Like, even if you do win and the other side has to pay your attorney's fees, well, if you're Theranos and you lose, well, they declared bankruptcy. You're not getting anything out of them. And so again, this is a longer discussion than I have time to talk about, but just know sometimes you can, sometimes you can't. And since it's 12:30, let me just, I'm going to end this meeting. I'm going to